We're very pleased to present to you this informational forum on special needs trusts in partnership with New York Life Insurance Company. For those who may not be familiar with ECF, we were founded in 1946 by a group of concerned parents who pooled their resources to create a daycare program for children with disabilities. Over the last 78 years, ECF has evolved into a nationally recognized organization, serving nearly 4,000 people with special needs and their families each year, from 14 program sites in homes and in the community across Los Angeles County. We are so proud to provide a full lifespan of services for children and adults challenged with special needs, empowering them to reach their greatest potential and live their best lives. This building actually houses our headquarters, as well as our Kane Aris TK through 12 school. And as you can see, we've been really busy getting ready for another really special event, which is happening tomorrow, our 2024 graduation day. Woohoo, yeah. I want to invite any of you who want to learn more about our services to stay after the program and take a tour with us. Tonight, we're very pleased to host this panel of top experts to discuss a topic that is so important to those with family members and dependents with special needs, planning for the future security and well-being of your loved ones. And now it is my pleasure to introduce tonight's moderator. Jory Rand is the anchor for ABC Eyewitness News Weekends and an Emmy Award-winning reporter. Jory came to ABC 7 from KDKA-TV in Pittsburgh, where he won 2 Pennsylvania AP Awards and 4 Golden Quill Awards from the Press Club of Western Pennsylvania. He lives in North LA with his wife and their 3 children. He's a foster parent and passionate about foster care and adoption. We're so happy to have him with us as our moderator. Please join me in giving a very warm welcome to Jory Rand.
It's always awkward hearing about yourself like that. Thank you, Veronica. I am Jory Rand from ABC 7. I want to thank everyone. I want to thank ECF for having me. It's an honor to take part in this forum. I know a lot of you have a lot of questions. A lot of important information will be shared tonight, and we have a great panel put together here for you. We'll be going over a lot of things. We'll probably be going over some things that you didn't even know you needed to know, which, just in my brief conversation with these incredible people, showed me how intricate it is and how detailed it is and what you need to know. So the questions that you have are important. We will try to have everything answered. I'm sure you come with very specific questions. We're going to try to get to everything, and if we do not touch on what you want to know, we're going to open this up to questions at the end. I know we have, I think a lot of you picked up some of the paperwork over here. If you didn't get any, feel free to pick some up before you go, and of course the tour at the end. So, before we get into this, I want to introduce our panel. We'll have them introduce themselves, tell you who they are, what they do, and what they bring to tonight's panel. So again, thank you all for joining us. I know Pittsburgh's in the house, so I just want to thank you for that warm welcome. But Samson, you want to kick us off here?
Hello, everyone. My name is Samson Mulugeta.
Check.
And I'm the Director of Client Employment Services at ECF. We're delving into a crucial topic today that impacts our community. And from my experience, I've seen how pervasive misinformation and confusion can be regarding this issue. Fortunately, we have a distinguished panel of experts who will bring much needed clarity and insight. The topic of special needs trust is critical for the disabled community for many key reasons, none more important than preservation of government benefits and just peace of mind for families. With respect to SSI, Supplemental Security Income, that's a top priority for many. We hear it all the time. As you know, SSI is a federal income supplemental program funded by general tax revenues. And the starting point for many families is to make sure that those government benefits are not interrupted or impacted. So today, hopefully, the panel will explain to us how the SSI for families can be protected while still receiving trust funds. So I will be asking some questions on behalf of the community we serve. I did an informal polling of the people we serve, and I've come with 3 questions that I'll be asking later. Thank you.
Thank you. Jennifer, you have next?
Hi, everybody. My name is Jennifer Joseph. I am a financial professional with New York Life, and I am here to kind of help explain how to fund special needs trusts and an estate plan for families with dependent children and adults at any stage of their life. So that's kind of where my expertise is, and that's what I will be going over today. And I've been with New York Life for about 4 years. So.
Okay, thank you. Jenny, you're up next.
Good evening, everybody. My name is Jenny Chow. I am an attorney that represents primarily individuals with disabilities, and I advocate for their special education needs as well as their regional center needs. I will discuss briefly about the kind of cases and the clients we represent and how sort of that plays into the need for advanced planning as well as for special needs trusts.
Great, thank you. Michelle?
Hi everyone, I'm Michelle Wolf. First and primarily, I'd say I'm a parent of a 29-year-old adult child with pretty severe disabilities who is a consumer at Lander Regional Center. And then the main hat I'm wearing tonight is founding executive director of JLA Pooled Special Needs Trust. And you'll hear more about our agency later, but it came about from a project at Betsett Legal Services. And we're a local resource for many of you families.
Excellent, thank you. And Steve?
I'm Steve Beltran, and I too am a parent of a child, an adult. She'll yell at me if I call her a child. She's a graduate of this school. It was one of the first graduates of this new campus that they had. So we've had contact with this school for many years. I'm a lawyer. I practice in special needs. I do litigation for special needs students and foster children. And kudos to your interest and your participation as a foster parent. That's a tough job, but it's a really wonderful thing to meet you here in that context as well. My practice, though, deals with litigation for children who are injured in school or who are the recipients of funds that come from family. For example, Aunt Louise, who passed away and left $100,000, or Grandma and Grandpa, who set up a minor's account for the child at birth, and then the child has special needs and is eligible for the money now at 18. Who here has can I?
Of course, of course.
You can see I'm not shy about talking about this because I've done this so often. I put on this type of program both in English and in Spanish, and we do it through the county bar with Michelle. I've worked with her for many years, and with Jenny as well. Jenny's firm and I are working right now on cases, 2 cases in state and federal court, two cases that are both in state and federal court for children who were now adults and were foster children through their minority, had a serious history of mental illness and behavioral problems, and had denial of special education and civil rights because they were kept in psychiatric hospitals. That's an example because county BCFS didn't have an appropriate foster placement plan for them. Okay? That's a sample of the kind of cases that come up. But what all of this comes back to is you need to have an estate plan for your children. Whether or not you've got children, you need an estate plan because you'll get to probate court and I may be seeing you in that capacity. Or, and better, that you have an estate plan for your child with special needs, because then you do a lot of different things. That's the handout that I was foisting on all of you at the start here. That's the outline that we'll be referring to, I will be anyway, from time to time. it's really helpful to, I think, to have a general global understanding of what special needs and estate planning law is, especially for people with special needs.
Well, perfect. Let's get into it right now. So I'm just going to basically direct the conversation, and some of the topics might bleed into another, so the panelists will be able to go from one to the next, and we'll get things going. Does anyone here have a special needs trust set up right now? Does anyone not know what a special needs trust is? Perfect. That's why we're here. Okay, so before we get to anything else, let's just start off with what it is and who would need it. Steve, if you want to start us off.
Okay. Special needs trusts are a part of an estate plan that you can all put together, or that someone can put together for your child or the person they want to leave those benefits to. And it allows for continued eligibility, as Samson pointed out, to receive government benefits. The government benefits that are critical to our kids, it could be before they turn 18 or clearly after they turn 18, they're eligible for SSI. SSI monthly payments right now are about $1,500 to $1,600 a month, and there are changes, incremental changes on it. That's the maximum. There are other types of Social Security benefits beyond SSI, but when you get SSI, you get Medi-Cal as well, so it's a type of medical insurance. So those components are really critical for your son or daughter. And if you get an inheritance and it's not sheltered, you go over the needs or the limitation for eligibility for SSI. Two parts to that eligibility. It's that they have a substantial handicapping condition, that's the first condition, and the second is that they have no more than $2,000 in non-exempt assets, no more than $2,000 in cash. You get that inheritance for $100,000 or $15,000, and it's really more a pain than it is of a benefit. What are you going to do with that? We're going to talk about how you can handle those matters, but a special needs trust is the one you want to use to anticipate the need of any money coming in like that, and it should be part of your own living trust. The example, if I may, is that husband and wife set up a trust for themselves, a living trust, so you don't have to go to probate court because you've named everybody to be your executor. That's part of the handout I gave you. On the passing of the second of the parents, the money goes to, let's say, my family, I got 3 children. I want to leave equal parts to all 3 of my children. My child with special needs, though, I want to put in a special needs trust. So her third share, she gets to share equally with my children, promotes her best interest in that context, but I also protect her eligibility for SSI. Now, it's not a guarantee that Social Security Administration is going to recognize and accept the special needs trust, because a lot of supervisors you get change from time to time, and they're always reinventing the wheel. So you can get your benefits cut off, and then you have to dance with SSI about reestablishing the eligibility for SSI.
I see a lot of heads nodding up here. This sounds very confusing. Anybody overwhelmed already? We still with us?
No, we got parents with special needs.
Yeah, you guys are on top of it.
Yeah.
Do we ask questions at the end or
Yeah. I think we'll save it to the end. Hopefully we'll.
Okay.
Yeah. So okay, it's not on the script here, but let's say someone wants to set up a trust. Who do they go to? How would one go about doing that?
Well, our nonprofit agency provides something called a pooled special needs trust. So if you're a middle-class family or even upper middle class and don't have complicated assets, we might be a good solution for you, because our nonprofit acts as trustee. I'm a licensed professional fiduciary, as is one of my colleagues. So when people receive our services, it's the same high level of fiduciary oversight that you would get in a bank or a commercial trust. The thing is, banks and commercial trusts, they're going to want to see $1 million. And we know that middle class and even upper middle class families don't have an extra $1 million, laying around anywhere. So I don't know if you remember the old, the first advertisement for the Mac computers. They said, a computer for the rest of us. So I like to think of our services as a pool trust for the rest of us. If you're a high net asset family and you already have a wonderful estate attorney, an accountant, an investment manager, you probably don't need our services. But if you're if you don't belong to that group I just mentioned, like I said, we do have affordable trustee services at the same high level of fiduciary oversight.
Okay, let's get down the line here, Jennifer. Let's talk about how people put money into a special needs trust. Should the day come when someone might need it, or when they turn 18 and have access to it.
Right. So technically speaking, people don't actually put money into a special needs trust. It's going into a product where the trust then, will say how the money will be dispersed when the child turns 18, or if a parent passes away, etc. But when it comes to, so special needs trust and estate planning go hand in hand for us. Like you can't separate it. It's special needs is like an additional arm of estate planning. And how we look at estate planning is kind of like a financial house. So the basement of it is you have to be properly protected. So whether that will be like insurance as the parents and guardians themselves, whether it's life, long-term care, disability, to make sure if something happens, your child is taken care of. And if something does happen, that proceed will actually go through the trust and be dispersed to the child child or adult at that time. So for those who don't have a very large estate and they still need to continue taking care of their child, that's where these insurance proceeds come in handy, and no taxes are due on it as well. So insurance proceeds, there are no taxes. That's like the biggest benefit of insurance. And then, of course, part of the protection is you have to have an adequate will and trust set up, special needs, estate planning will, all of that set up, so make sure the proceeds go to the right people, and a proper guardian is set up as well. Am I answering the question, right? Okay. So after that, the next level is kind of the accumulation of wealth. So this can happen in the entirety of the parent's life and the child's life. So parents can accumulate wealth for themselves in retirement accounts, tax shelter accounts, insurance products, etc. And they can also accumulate put accounts in the name of their child, or a grandparent can do it, or a family member. They can open an account on their child and have the funds dispersed to the trust so that they can still qualify for all the other government benefits. So those are accounts that will be open on the child so that they have something after they reach 18, whether it's for college or whatever it may be. And then at the same time, the parents' assets will be growing too, whether retirement, insurance accounts, etc. And then the final stage is the disbursement. So for the parents, that would be, your retirement account. For the children, it would be, when they reach 18, the funds will be dispersed. Now, if it was correctly tax sheltered, you wouldn't have to pay too much taxes when they're dispersed. That's where, the whole financial planning idea comes from, because you want to keep more money that you make. And then the final thing is, after the parents, after your time, you still are passing on an estate to your child or your adult at the time, to your, next of kin. So you want to make sure that if there's any taxes due or anything like that, your heirs do not have to sell your property or, any real asset to pay for taxes, estate taxes, etc. So that's where like permanent insurance and all of that helps with that. And so, your heirs can still live in their house, be happy, they don't have to sell it. And also the estate plan will avoid you from going to probate court as well, which is not fun. There's like, correct me if I'm wrong, I think there's like a 2-year waiting period in California for probate court?
14 to 18 months.
14 to 18 months, okay.
Yeah. You file your petition, and you've got to do work.
Yeah.
Probate, you've got to do on the clock the way the court tells you. File your petition, you get your letters, you get your inventory and appraisal you have to file, you marshal the assets, you've got roughly 2 years to complete to do a petition for final distribution. The problem with a probate, which is when you don't have a will or an estate plan, is you have to pay attorney's fees based on a schedule of 4% of the first percentile, 3% of the next, and 2%, in addition to whatever additional costs. So that cost can be expensive because if you have a large estate, $1 million, buying a house right now, name a house around that's less than $1 million. You can find them, the lowest that I'm seeing around 700, 600,000 right now. And that's a big chunk to come out on taxes.
Right.
Or expenses.
So, yeah, my realtor friend, he mentioned how probate court is here. In different states, it varies. So if you have assets in different states, your children do have to go to probate court in every single state. And if, it is a special needs child or adult, that is not something you want to put them through. So having a proper estate plan, and then our accounts will go through the trust. So it's not like the money is in the trust, to answer your initial question, kind of to wrap it up. It's not actually in the trust, it's in a product, whether it's a retirement, a college account, an insurance account, whatever it may be. The trust just makes sure that it's dispersed correctly and there's proper guardians and all of that. And then, anything after your time, your children or your heirs don't have to go to court. So that's how that works.
Perfect. I do want to get to Cal Abel here in a little bit, but I know you wanted to talk about estate planning a little bit.
Yeah.
And some of the risks of not doing so. We heard a couple right here.
Yes. Jennifer just pointed out a couple of very good ones. Mom and dad die, don't have a will, and your child's under 18. Who's the guardian? You didn't name anybody. You can nominate in your estate plan who you would choose to be the guardian of your children. If you have a child with special needs, that takes somebody with particular knowledge and care and interest and tie to that child about promoting it. The same thing goes about conservatorships. If the person's over 18 and under a conservatorship and you pass away, who's their successor? You left it in the lurch.
Well, who would it be? Who would it be if you don't name someone?
Well, that's the problem. That's where you come up with organizations like JLA and these trusts that come up. The fallback worst option is it goes to the public guardian, and they're overwhelmed, and they don't particularly take cases of people with developmental disabilities. That's a really unusual thing. I've pointed this out to them. Isn't that discrimination? Well, we don't have the staff to do that.
Well, they expect, everyone expects the regional centers to take. So if your child's regional center and no one is named to be the legal guardian and the person really needs a conservatorship, then the regional center can step in, petition the court, and step in and become the conservator.
No, that's a pet peeve of mine. My first job was a client's rights advocate for East LA Regional Center, and I left that to go on to my other pursuits. But I've come into other cases. One of the clients I had was for a conservatorship of her daughter. She was a real aggressive advocate against the same regional center. I later became the president of that board of that particular regional center. And the regional center had to do a report to the court on this conservatorship petition for my client. And they came back against my client. And what do you think I did about my board position? I resigned. Because there's a conflict that regional centers have. They get money from the State Department of Developmental Services. They put together an IPP or an IFSP. They have a plan that they fund for the services for your child. But they may not be willing to pay all the services you ask for, and you have a right to appeal their decision. There's a procedural right to that. So there's a built-in conflict for them managing the money. I have a couple of cases where they've been the conservator of the estate and they've gummed it up and lost SSI benefits, and you get this chunk of money and you have to remove them. So relying on the regional center or the Department of Developmental Services as the successor conservator or guardian is not the best plan.
Yeah.
A couple more risks. Do you have any more risks of not setting up an estate plan in a situation like some of these? in a matter of time that we can handle here
I have
tonight.
one more.
Yeah,
One
Jennifer.
more to add. So usually when if you don't have an estate plan, you go through probate and the court decides who gets what. So if you want to leave something like more for your special needs child or adult, but you have 2 other children or maybe some like siblings or like they will decide purely like how it gets divvied up. You have your child or anyone has no say, so they may not get what you wanted for them to get. So that's like a big problem. So not only do you have to go through the months and months of probate, usually the judgment is not very much in the beneficiary's favor.
Yeah, go ahead.
Something to add in terms of planning ahead, just sort of in the special education context as well, it's presumed that once the individual turns 18, they have full legal capacity and legal rights, which can become problematic when, the individual is so disabled where they can't make educational decisions or they don't know what to do with the SSI. They can't set up a bank account because it wasn't set up for them. Or parents don't have access to, their child's medical records, and they, certainly can't make the appointment by themselves, or, fill prescriptions on their own. So very, very important to make sure you plan ahead and well in advance. I think there's at least a 6-month waiting list to get conservatorship started, right?
Yeah, the IEP, your individual education plan, when the student turns 18, they're presumptively competent. Doesn't matter what level of disability they have, they're presumptively competent until they are conserved. So the school district on the IEP will automatically seek the authorization and consent of the student on the IEP if they're not conserved.
Wow.
Okay, so some caution to everyone out there. If you don't have a will, if you don't have an estate plan set up, now is the time to do so. We're coming up on the top of the hour. We made kind of a run through. I want to ask Samson, do you have any questions on any of these topics?
Yes. One question is, how does having a trust affect my SSI benefits? If you kind of deep dive into that, explain.
Did everyone catch that? How a trust might help SSI benefits?
So if you have a valid special needs trust, the beneficiary will be able to keep their SSI benefits, plus be able to have access to money that is in the special needs trust, and if there's investment income that comes from those assets.
Like for what?
What do you mean? What to use it for?
What kind of example can you use the money from the trust for? And
So it's pretty wide, and it's really it's at the trustee's discretion, but it's all about improving healthy outcomes, independence, and most of all, quality of life. So depending on the client, some people like to travel and go to Disneyland. Some people go to Vegas. Some people want to have 3 dogs. Some people want to go bowling every weekend. So it's really very individual in what people need and want. Almost all of our clients use their trust funds for things like a cell phone, internet, streaming, Lyft or Uber, and then buying things like things that you might need in a drugstore that aren't prescription, clothing, things for the house. And then some of the clients, if there's enough money, can even use the funds to purchase a vehicle, or in some cases, a residence. If they purchase a residence, it has to be a primary residence of the beneficiary, someplace that they live. So it can't be a rental property. It has to be someplace where they're living. So basically what we say, as long as it's legal, pretty much you can buy, or at least request, anything that you want.
which goes to the importance of who you select to be the trustee and the relationship that trustee has and knowledge of your child's needs. Because there's clients I have that love to go to Disneyland. Every year you're buying them a season pass to Disneyland. And the travel example is really important and a good one because it includes the air travel, lodging, and meals for one attendant plus the child, plus the person who's disabled. So these all, yes, they're all to enhance the quality of life. Anything really that enhances the quality of life and does not take the place of a government benefit that's being provided.
But the trustee would have to sign off on all those expenses.
The trustee has absolute discretion and decides. That's why the dialogue between the trustee and a person like Michelle, she's a great trustee because you talked to her about, she's a trustee on a couple of cases, so they're full disclosure, that I work on. So I know, and I'm a trustee on a couple of trusts myself. So.
I know, Michelle, you talked about your organization does that and can act as a trustee, but how would someone decide upon who is going to be the trustee?
So a lot of middle-class families, the first impulse is to pick like a sibling, a cousin, a family member. But that is not the best practice for a number of reasons. Quite often, you're creating a tension between the child with special needs and the neurotypical child. And you can imagine having somebody who texts 5 or 10 or 50 times a day, why won't you buy me the new video game? I want that new video game now. Actually, video game is the least of it. Why won't you buy me the new Ferrari? I really want a Ferrari. So you can imagine that could create a lot of tension. And there's a lot of information that trustees have to know. You have to keep abreast of all the government benefits, and there's often a lot of changes with them. You need to keep abreast of what's happening like in the world of regional centers and their various offerings, and also tax implications, and also investment. So that's asking a lot for a sibling. So that's why we exist, and we have a role for siblings or close family friends that we call beneficiary advocate. So what that means is it's a non-legal liaison. So the sibling can be part of spending plans, the sibling can be called upon, the sibling can get copies of statements, but at the same time, the sibling does not have any legal responsibilities. And, they can play a little good cop, bad cop, right? The sibling could say, gosh, I know you really want that Ferrari, but that mean trustee won't buy it for you. And, we don't take it personally.
That's good. That's good to know that. Jenny, it looked like you had something to add.
Oh, I wanted Steve to clarify what the trust can't be used for. He sort of touched upon it, that it can't.
Yeah. The trust cannot pay for. The point of the special needs trust is to protect eligibility for government benefits. Okay, that's the SSI and Medi-Cal. That's based on their need, their financial need, and their disability. There's another component, though. There's another type of Social Security that comes from yours and our contributions to taxes. We have a disabled child. When we retire, our child can get contributions based on our taxes and what we've contributed. So that's not based on need. That's based on an entitlement that they've earned, that you've earned for your child. So you can combine the retirement component, the SSDAC, I think it's called. It's in the notes there, with the SSI, but you can't get more than the two programs combined, maximum of either one, which is roughly $1,600 a month right now. But you also qualify for Medicare. You get what's called Medi-Medi.
After 24 months.
Yes.
Yeah.
You get Medi-Medi, you get Medi-Cal and the Medicare. So you got dual insurance just through the government components that you've got through Social Security. But you cannot pay for things that are otherwise provided by SSI and Medi-Cal. Now what happens if Medi-Cal doesn't pay for some insurance component or thing that's needed, like a wheelchair, an electric wheelchair, or a van with a lift, or an orthopedic bed or a hospital bed, something like that. The trust can pay for that. What about school? That's a question I have for you. I want to throw this back at you. Would you think that a portion of school expenses could be paid for from the trust?
To the extent that the school district denies the service or the supports, then yes, because the trust is meant to enhance and improve the quality of life as well as the quality of education one seeks. So, the school district isn't going to be responsible for, say, a college tuition or anything like that. To the extent that the Department of Rehab won't cover the books or the tuition, the Special Needs Trust could cover that.
It's enhancing the quality of life. That's the big point.
Right.
Keep that in mind, because that's what you want to do, is keep your child to as much a level that you've provided them in your lifetime.
Have any of you encountered a situation where a family wants to access something they think is for quality of life and are denied?
Yes, I've had a trust a couple times where the trust is set up, and this is the caveat I gave earlier. If it's a family estate plan trust, before I get to your answer, there's no payback to Medi-Cal at the termination of the trust. That's a big, big point. But if you don't have an estate plan and one needs to be created for your disabled family member, and it has to go through court supervision, then there's a payback to Medi-Cal. And it goes not just from the date they qualified first for Medi-Cal, but it goes back to the first time they qualified for the benefits to begin with. So it can be millions of dollars. So yes, I've had trusts that were monies that were received from a medical malpractice case. We got the trust set up, court supervised. We took it, and anticipating one of Samson's questions, which was, do you have to advise?
Yeah, the question is, how do I report the existence of my trust to Social Security Administration?
Yeah, when you do a court supervised trust, you have to give notice to 3 departments of the state of California: Department of Health Care Services, Developmental Services, and the state hospitals. And they have a payback. The Department of Health Care Services has a component dedicated only to recovery of Medi-Cal payback. So you're going to be facing it, and you have to report it. So even though I've had a trust set up like this, and every accounting you do on a court supervised trust, you have to give copies to these agencies. They know about it, but I've gotten my client has received notice that their SSI benefits were terminated because they had too much money. You say it's not their money, it's the trust's. Well, you have control of it. No, the trustee has control of it, but it's court supervised. No, but then you go into this whole battle with Social Security just to re-educate them periodically.
To re-educate Social Security?
Yeah. Okay. You're always fighting that battle. You're fighting the battle with the school district, with the Social Security, and with regional center. Those are the 3 providers of services that you're always advocating for. So when I say battling, it's advocacy that's constant.
Yeah. Has anyone here experienced anything like that? Those battles? No? I saw a head shake, but I saw a couple hands as well. This caught my ear when we first talked about this a couple of days ago, having to pay back. Yeah. Explain to me a way to avoid that situation so someone doesn't get locked up in that.
The best way to avoid payback is to do an estate plan that incorporates a special needs trust in it for your disabled child, because there's no payback requirement for that.
That's the difference between a trust and a special needs trust?
A first and a third party.
Yes.
Got it.
The first party is you do your own estate plan, and you set up in your estate plan your own plan for yourselves, the A, B portions of the husband to wife, etc. And then on the death of the surviving parent, the money goes to your children, and the child or disabled family member that has special needs, that component is in a special needs trust that you've included in your estate plan. So one question that was asked at the very start was, who does these? You need to have somebody that's experienced, an attorney that does estate planning with special needs trust knowledge. You can't just go to any lawyer. And you can't do it on your own, because you don't have the skills to write the same words and include all the little magic language. The absolute discretion of the trustee, the payback requirement is or is not applicable. There's a lot of detail that's required in setting up a trust, a proper first-party trust. When it gets to a third-party trust, you've got to pay back.
No, the other way around.
Excuse me. Okay. But other than that, I'm right.
I know some people, they're like, well, I really can't afford a trust attorney. My brother-in-law does trademark law, so he'll do our special needs trust. And so, I'm sure he's a nice guy, and he goes on the computer and he gets, he gets some kind of form that, rip and fill out. But that's not going to be the right plan for you. You really, this is something worth spending the money on and going to a trust and estate attorney. And a lot of people ask if legal aid or neighborhood legal services or BetSetic will do this. For the most part, the answer is no. BetSetic does it for in very particular cases where people have a house but no other assets, and they want to keep the house in the family. But by and large, you have to pay for the services of a trust and estate attorney. There's really no getting around it.
I can actually add to that. So I'm not a trust estate planning attorney. I just want to start with that. However, I do represent New York Life, and I'm a professional with them. So we actually have certified estate planning attorneys who specialize in special needs trusts that help our clients. So that's kind of like a starting point that we have, and then we can kind of help you out to find the person to write it. So yes, we do have inclusive of our services. We create the financial plan for you, but then we also have attorneys that help with creating the estate plan and in this case the special needs trust as well.
So that would be contacting someone like you, Steve, or contacting someone like you, Jennifer, and saying, this is what I need, and can you direct me and point me in the right direction?
Yeah, this is something that's really important, because let's say it's $5,000 ballpark for an estate plan. That's way less than what the attorney's fees are on a probate. Just think of that. And it might be pinching you right now to do that. But the other thing too is you want to screen who that lawyer is going to be. You can look online for estate planning and special needs trust lawyers. That's another way you can look. The LA County Bar has a referral service that you can say, I need a referral for a special needs trust and a living trust estate plan. There are a lot of ways to do it. Do some homework, look online, get familiar. You folks are savvy, I know, because you're here and you're already talking with, we're in the same world about special needs and who we deal with. So look that up. Be advocates that way too for yourselves.
And then we just wanted to add, so the attorneys that I mentioned are actually in-house, but and that they come with the services that we provide. But the actual writing of it, we do, like you said, we do refer it out to some of our partners. So the in-house counsel is, that's complimentary to all of our clients. It's like getting your foot in the door. They give you all the recommendations that are needed for the trust, and then we refer out the, to our partners, the actual writing of the trust.
Great. Samson, do you have another one? No, you're good? Okay, anyone want to talk about CalAble?
CalAble.
Let's talk CalAble. Does anyone know what CalAble is?
So CalAble is a great way to save money for your child with special needs. So it was passed under the Obama administration called National ABLE Act. If anyone's familiar with 529 college savings accounts, the ABLE accounts are modeled on them. But the big difference is money that is set aside in these CalAble accounts can be used for a lot more than just post-secondary school. It could be used to purchase wheelchairs, medical equipment, computers, many of the same things that a special needs trust can be used. So you can only do it online. You can only set it up online at CalAble, CalAble.org. It was created through the California State Treasurer's Office. And they've got a great website with a lot of videos. And what's nice about it is not just family members, parents can contribute, but friends, so like at a graduation, you could, like a GoFundMe kind of a thing. You could have friends and relatives contribute to the CalAble account. And you can go all the way up to $100,000 in a CalAble account and still keep your SSI. The one big limit is with CalAble accounts, you can only deposit on an annual basis whatever the IRS gift tax exemption. So for 2024, that amount is $18,000. So what that means is if someone inherits or gets a legal settlement of more than $18,000 in the calendar year, CalAble is not going to be the right solution. But it's a great thing, and we encourage people to actually have both a CalAble account and a third-party special needs trust. They serve different purposes, and you can move money in between the two accounts.
Perfect.
Okay.
Before I open it up to questions from the audience, does anyone have anything specific that you think we missed and want to touch on before we open it up?
I just want to emphasize, do the estate plan of your own and avoid the payback. That's the most critical thing that you can imagine, because your own estate plan also includes your nomination of who would be the conservator or the guardian of your child, and how you can even, in your estate plan, you're going to have a letter of intent or of a will. You're describing what you would like to do and the level that your child has lived with you there. But there are a lot of things that you can do just in your own estate plan.
Yeah, go ahead.
I would just like to add that if you plan on conserving your disabled, family member, to start the process early and really plan ahead in terms of what you would like to see for them for transition support, as well as the estate planning, starting that very early. And you and I talked about this a little bit,
Yes.
but
Yeah.
insurance, start
Oh,
that
yeah.
as soon as you can.
Yeah, so I just want to emphasize what Jenny said about the estate plan, because I work in the world of insurance and investing, and insurance is, relatively inexpensive the earlier you start, but it can become a burden, the longer you wait. And then when it comes to investing, whether it's for yourself in a retirement account, or any account of that nature, or for your child in a 529 or life insurance for themselves, it's all time value of money. The longer, the earlier you start, even if you can, do something small, the time value of money will work magic. And then it's always like you can build up from there. And then at minimum, like everyone mentioned, that will and trust needs to be set up, because, without it, even if you do have assets, your, dependents have to go through the 7 C's to get them. So yes, that I want to emphasize that one again.
Do you want to go through?
What, the 7 C's?
Yeah.
I don't know, what, the 7 oceans?
Jenny, you talked about doing this earlier. Was that just to get what Jennifer was saying, to get as much money, or is it the process of getting something set up? It could also be lost there.
What age?
Sooner rather than later.
You don't have to wait until 16 or 17 years old to start that conservatorship?
17 and a half.
Oh,
Conservatorship, about 17 and a half, start the process. Work with your regional center, start getting those reports ready. Is it like a court-appointed investigator? There's a lot.
Yeah, the process for if you want, we can talk a moment about conservatorships and guardianships. Let's say you did not have an estate plan. You pass away and your child is a minor. You then have created the need for a guardianship of the person, food, clothing, shelter, as well as of the estate, the money that's due that child. And then you're going to have to take care of that. And so the court would have to deal with the guardianship in that context. Alternatively, you have no will or estate and your child is an adult. Now, instead of a guardianship, in California there's a distinction. Guardianships is to minors, and for adults it's called a conservatorship. For regional center clients, it's called a limited conservatorship. But the point is to be in the least restrictive means of protecting and promoting that person's independence. There are powers that a conservator has under a limited conservatorship, and they go to where you live, contract, education powers, social, sexual, marriage, access to private records, and there's that one
Contract.
contract. Okay.
It's important.
Yeah, those are the 7 powers. And it could be that your child needs all or none of them, or a couple of them anyway. The core ones are contract, school records, and medical consent. But other than that, those are the issues that are dealt with on a conservatorship for an adult. And the court will appoint a lawyer for your child on a petition for a conservatorship or on a guardianship petition. And that lawyer has to do the bidding for that client to represent them through the conservatorship. The regional center has to make a report on a limited conservatorship for an adult on whether or not the 7 powers or any of them should be granted, or whether that conservator parent petitioner should be appointed. So that's not binding. That recommendation up by the regional center is not binding, but it's an important point that the court has to consider. So all of these things are at play, and that's why it's important for you to do this ahead of time. Anything?
Well, I was just going to say there are some parents out there who would rather not do a conservatorship. An alternative is to do a power of attorney. There's also something called supported decision making that some local groups are working for. So it's important to do one of the above, depending on the needs of your particular child.
The other component of the guardianship or the conservatorship of the estate is it may require the establishment of a court-supervised special needs trust for a minor or for an adult. Subject to what? I want to hear it. Payback.
Medicare.
It's subject to a payback because it's court-supervised. So you left a hole in the boat, a couple of holes in the boat, and those are what you have to plug. That you got to do that now. Jenny's point about education and independence and transition planning, that's usually it's around 14, right?
16.
16, okay, but those are the lessons that the child learns: to take a bus, to make a meal, to do things independently, know how to do their laundry. And that doesn't always get done, but you got to promote that. That's part of the mix. But for education purposes, that's what's included in IEPs typically, right?
Right. They need to start by no later than 16 to have their first transition plan. But that also plays into starting to get the Department of Rehab involved if we're talking about vocation or enhancing that independence, as well as getting the regional center involved in the IEP meetings, so that, because at that point, if you're thinking about a 16-year-old, a typical 16-year-old would want to go to the movies. How do we promote that independence to allow your 16-year-old to go to the movies on their own in the community? The regional center can support that.
I have one other question of Jenny. What happens if a special ed student gets their graduation diploma?
Then they're no longer eligible for special education, and the regional center is then responsible for their independent living or supporting their independent living.
What happens if they don't get the diploma and they get the certificate?
They continue to be eligible for special education until age 21 or 22, depending on where their birthday lands. So they continue to have access to special education supports, including vocational training, transition supports, and academics. But after they get their certificate of completion, at that point, the regional center does take over in terms of their daily living. So it could be, funding a day program to, learn those vocational skills. It could be supported work. It could be a day program just for socialization. But anything to increase their independence that would be appropriate for them.
And finally, once they are out of the school system, Regional Center and Voc Rehab take over for planning for your child as part of the conservatorship's duties. Okay, there's a continuity that you're looking at.
But it's important to know that regional centers cannot, they're legally prohibited from paying for rent. So that's where your SSI, your SSDI is supposed to pay for rent, or CalAble, or your special needs trust. I mean, the problem is, of course, that SSI right now is about $1,133, and if you're supposed to, only use 1/3 of that for rent, that would be impossible to find anything, within a 100-mile radius of this building. So a lot of parents, if they have the means, plan ahead by doing things like buying a condo, or building an ADU is now something a lot of families are considering, and they have changed the ADU rules with all the local municipalities to make it easier to do that.
Okay. Just to thank you to this panel. Just incredible.
Thank you for coming.
Just to get an idea, do we have questions that people want to ask? Okay. So let's just go one by one.
The lady in the back had her hand up way back when.
Oh, thanks so much. Hi, Michelle.
I know.
She's great.
Loud,
so,
please.
So I'm originally from Canada. What if we move? What if can you just get all the money and however way and just go to move to another country?
Establish residency.
Well, yeah. Well, you lose your SSI if you permanently move somewhere.
No, I thought she was moving. You're moving here, or?
No, supposing I have CalAble, or supposing I have a special needs trust or something, and supposing I pass away, and my siblings are in Canada, and they say, hey, this child, this nephew, he should live with us. So then what happens? Something like this. I mean, what if a person moves to New York, or they want him to move to another state? Then what happens?
You lose your SSI if you permanently move out of the country, which is different than your Social Security retirement, which you can take out of the country.
I think the question, tell me if I'm understanding this, if you assign somebody as your as the trustee to the special needs trust, and then that person moves, is that your question?
No, the beneficiary.
I mean, I guess the beneficiary would move. What happens to the money that was put in the special needs trust? I'm just saying.
Oh, so what happens to the money in the trust if the beneficiary moves?
If you move out of, if the money that's in the trust still belongs to the beneficiary, they could be wherever they live. It's their money. If they move from California to another state, the CalAble account, for example, is recognized in multiple states. That's your answer for.
Yeah, but there might be different rules about payback after death, because each state has a different Medicaid state office.
So like SSI, if it's within the state, would continue within the United States. SSI would continue, and whatever other government benefits would continue. They might not be called Medi-Cal in another state; they'd be called Medicaid, but they're the same benefit, just identified differently.
So this hopefully would be something you would want to set up in advance. If you name someone, where that beneficiary is going to move to within the United States, set up and figure out the tax laws and the laws, the Medicaid laws, and that, or medical laws.
The trust. Let's say the trust is set up here, and then you move to New York. I have a couple of these that are happening now. The question is, where is the trust administered? Here, and so there's a choice the court has, either here or where the beneficiary resides. So you can transfer the court supervision on a court supervised trust. You can transfer it to another state. but you have to do it through the court. But you want that. If it's going to be a court supervised trust, you want the bond and you want the accountings every 2 years because you want to be sure that the trustee is not ripping off the beneficiary. And that's why you want a qualified, reputable trustee, not necessarily a family member, not to disparage any families in particular, but your point that was raised earlier, Michelle and I see this all the time, there's a conflict, that tension, that's a perfect way to put it, it's a constant tension. So trustees also run into that, but that's their job, that's what they're trained for.
So something to bring up with someone like you or someone in your firm when you're doing your estate planning.
Yeah, you talk about, these are issues to discuss with your estate planning attorney. There's a lady in the front here had a question. Oh, the gentleman behind you is right there.
Hi. So if you set up your estate plan thinking, not knowing that your child will be a special needs child, so you have an estate plan naming them as a beneficiary, you have a 529, you have a trust account in their name that they'll get control of when they're 21, all that stuff that you're supposed to do early on. What do you do now that you know you need a special needs trust and CalAble to kind of transition that to be protected?
You've done an estate plan and you have a child?
Yes.
And you, if I can presume that you've learned that your child has special needs.
Yes.
And now you need to amend your estate plan.
Yes.
To update it and to create the special needs trust.
It's been created.
That's what you do with your estate planning. You can do that. And when you do your estate plan, you can amend it periodically.
Right.
It's when you're alive, your estate plan is revocable.
It can be changed.
It can be changed. But a special needs trust, once it is established and has life, it's irrevocable unless the court allows an amendment. And that's done to protect anybody coming in and changing what you put together in your own trust.
So you have to just basically go in there, cross out their
right.
name and put in trust.
You're making it.
Yeah.
You're making it on your terms. This is one of the fine points of why you want an estate planning specialist. And you talk about it, but this is something that you include in your plan.
What about money that's already kind of been set aside, like in a 529 or
The 529 money can be rolled over into an ABLE account.
Okay.
There's federal law that allows that. So the thing is, the ABLE money can be used for so many more things than the 529. So there's really no downside to rolling it over.
What about if they have a checking account on their name? What do you do? Because you don't want...
Well, you don't want more than $2,000 at any one time. I mean, a lot of times you don't really even need a checking account if you have a CalAble account.
Or like a savings. I know, but like this is before...
This is what you want to talk to your lawyer about.
Yeah.
Next question. This is what happens all the time. No free consultations.
Lady.
Yes,
Yeah, right up front.
Yes. So my question, I don't have anything.
Wait for the...
Oh. I don't have anything established yet. Would you from what I understand, I should start with the estate plan for myself and include the special needs trust. That's where I need to start. My son is 14 years old. So that's where I should start. Okay.
Yeah.
You should start now because, and you're also going to be needing to talk about in anticipation of special education and being his conservator, conceivably.
Yes.
And so you want to, say you're gone tomorrow and you've done your estate plan, you can name all those things that you want in place and fund it as you're able. But at least you've taken care of that eventuality.
Okay.
And Michelle, you wanted to add?
How long does that take? How long does it take for me to do a estate plan? Is it?
So, do you have anything, besides before the estate plan, do you have any protection on yourself?
Insurance.
Insurance.
Like life insurance?
Yeah, life, disability. Okay.
So you say you have nothing, but you don't.
Yeah.
You don't have nothing. I hate the double negative.
Yeah.
But this is an interesting point. A lot of people think I have nothing. But no, I've got life insurance. Yeah, my job gave me this. Oh yeah.
I do have that.
Well, what are you going to do with that?
I put my mom has a beneficiary, and I put my children. I have 2 kids.
Okay, here's another little, be careful. Don't leave your money that you want to go to your child to someone other because they promised to take care of your child. It don't cut it that way. It's not legally enforceable. If you want to take care of your child, do it. God loves the child, has his own.
Okay.
Set it up for his own.
So yeah, at this point, you would, go to an estate planning attorney, through us or, anybody that you know. And then, we'd start kind of, putting the insurance and all that you have, building a trust around it to make sure you're protected and also your child's protected. Yeah.
It's a lot of good information. I had no idea about
You were
how
gonna charge.
much. I did not know. I knew about a
You are the one
special
we're going to
trust.
charge today.
Yeah. Thank you.
Any other questions? We need to get some questions on this
So
one too. 'cause
I'm the
they're saying
complete
it's not fair.
opposite of this lovely lady. I have, we have an estate plan, we have a special needs trust. We did it years ago when our kids were teenagers or early teenagers. Everyone is an adult now. We need to go back. We need to look at everything again.
Yeah.
We have 3 kids, the special needs adult, another child back east, flown and hopefully grown, another one here, also flying, I think. So so we have to go back and re-look at everything.
Yes, because
So
who you named in your estate plan as your successor trustee, as executor, as conservator or guardian of your children, those people may not be around, and you may not want those same choices.
So my question is, do you have certain things we should be considering now that were different than when they were all minors? Like, do you have any
Look,
tips?
that's subjective to you. Just look at what your plan is. Do you want it still in the way it is? Is there something you need to add or change?
Well, just wondering if there are any tips.
No, because I don't know your estate plan.
Well, one of the main tips, though, is a lot of people will appoint, like, you're the mother, and you think you're going to have your sister or your sister-in-law, right, become the guardian, but they're the same age as you or older, so you really want to think about who in the next generation, right? Who is close in age to the beneficiary? Who is close in age to the person with the disability who might be a good person to appoint?
But keep in mind the hook, the tie you have to your child, that we all have to our kids. And I call that the hook. That's what binds us to. Who do you know in your family that you would nominate that would have a similar interest and promote your child's interest the way you would like them to do?
Nobody.
Well, that's a harder one. So yeah,
That's the truth.
that's something you have to figure
Well,
out
then
too.
that's when you hire professionals. You
Right.
can hire private case managers, you can hire private fiduciaries. I mean, you can hire, investment managers. I mean, that's where having enough money allows you to purchase what you might not have, from natural supports.
So the point, I'm sorry, Joe, the point of who you would name, for example, as a trustee of a special needs trust, if you don't know a family member, but
Well, I
you
don't
have
mind
to find your
getting
own,
involved like
You have
that.
to find your own caregivers.
Right.
Yeah.
right,
Well, I mean, to the extent that,
or set your own rates that you're going to do it for.
but then
funding.
too, I could contract it out to an agency at $35 and say, I'm going to use you, if I have confidence in them.
Well, now these are all subjective things to you, okay? These are things I think you should work out with your service coordinator at the regional center. You might want to contact an advocacy group to help you further advise you. But it's not really part of, it's the nuts and bolts. We're really in the weeds on your case, to put it that way. Okay, we all have, I get the same issues with mine. My daughter's with Westside Regional Center. So we're doing the same, we're looking around and we're always finding, there's always a change in who's going to be there. it's just, it goes with the
No,
term.
I'm very appreciative of what they're trying to do in the environment we're trying to do it in. Okay,
Yeah,
so I'm
yeah.
not sour grapes or anything, but
Yeah.
self-determination was an option that I really thought we could pull it off. And they have advisors on the West Side Regional Center, you know, costs
Yeah.
plus
Yeah.
flat charge, that sort of thing.
I've not been in a hurry to go in that route because I may be mistakenly, and I'm an old guy now, because I think, well, when I was a client's advocate, I didn't want to, what I saw the self-determination being was putting the social worker's service coordinator responsibility on the parent or on the client. And I thought they don't have that skill set. And were you going to put it on the client to serve themselves? It makes no sense to me. But I trust, I've been hearing other people say that they like the self-determination. And what I've heard about West Side, and you've even read it in the papers, I have anyway, is that there's a disparity in the funding that goes to people on the West Side because they're doing the self-determination and getting way more of a share of regional center services than like Lannerman or North LA or any of the other ones.
Yeah.
So this is part of the advocacy, this is part of the battle you're going to be looking at on conservatorship or guardianship, which is why it's so critical for you to do the estate plan.
Jimmy?
Okay, so the bottom line, let's pretend I don't go self-determination. Who? If I decide not to go, where shall I go from this evening?
So what we tell our clients is no one's going to be able to replace you as parents.
That's right.
So it's going to take a team of people.
That's right.
But if we have clients who there's enough money in their trust that we hire a private case manager, and that private case manager is paid out of the special needs trust. Then that private case manager is the one interfacing with the agencies and with the regional center.
And it's not a government benefit that you're interfering with.
Okay.
But,
Jim?
yeah, you need enough. I mean, it's really one of the other really important takeaways: save money, invest money, buy life insurance.
Or annuities.
We're past
Exactly.
it.
Okay.
Yeah, hold
Well,
on. I wanna
okay.
hear
Well,
what you-
anyway, I'm giving up the mic. Thank you very much, and I'll call you tomorrow.
For self-determination, I would point out, though, that as part of the budget, you can have an independent facilitator who can help coordinate those services, and the financial management service who can help with hiring and firing and making sure that the employment laws are complied with if you do hire like your own caregiver. It's a good program. I'm an advocate for it, but I understand the change is scary.
Okay, so we're a little over. We have one more question, and then if you have a further question, then come see them afterwards. Steve's going to charge you, though.
So I have two quick questions. You mentioned there were 3 entities, if you have a special needs trust, that you have to notify. Social Security Administration was one. What were the other?
I said those 3 organizations: Department of Healthcare Services, Department of Developmental Services, and the
State hospitals.
State hospitals, Department of State, the directors of those 3 agencies. But that's only if you're doing a court-supervised trust. If you're doing an estate plan, you don't have to do that.
Okay, and
Because
then,
the point of their involvement at all or notice to them is because there's a payback requirement to them.
got it. And then my second question is, can you please briefly describe the difference between a third-party special needs trust and a pooled trust?
So in the pool trust, we have a master trust document written by an expert in the field, and everyone joins. It's called a joinder agreement under that umbrella master agreement. So the thing is, the way the money works is all the money coming into a pool trust has to be liquidated. So that's what I was saying. For people with more simple estates where their money is in relatively, non-complicated assets, it can be easy to liquidate. If for families who own a lot of real estate or their own family-owned businesses, you're going to need a standalone special needs trust.
And failing that, you have a court supervised, which is the third party, where the court gets involved, and there you have all the accounting, and you can have, substantial assets, 8, 9 digit figures, managed, but subject to the payback.
Okay.
That's it.
Again,
That's all.
let's thank our panel again. Thanks for being here. Jennifer Jokin, Jenny Chow, Michelle Wolf, Steve Beltran. Thank you to ECF for hosting this. Veronica, thank you so much. And again, tours are available in the facilities if you'd like to. And thanks everybody. I hope you got what you needed.